DZXL 558 RMN Manila. Extra large sa balita at komentaryo. Extra large sa tugtugan at extra large sa serbisyo publiko. Sama-sama nating silipin ang mga kaganapan sa bawat sulok ng Metro Manila. Mahigpit nating babantayan ang bawat issue sa inyong mga lugar at sabay-sabay nating bigyang solusyon ang mga problema sa inyong mga komunidad. Dito lamang yan sa DZXL, Pulso ng Metro.
Magandang hapon mga kasama. Ito po ang Pulso ng Metro. Pero po sa ngayon mga kasama ay magbibigdaan tayo para po sa nagaganap na pagdinig ng Senate Blue Ribbon Committee. Kaugnay po doon sa CGTA at ihahatid po sa atin yan na ex-Radyoman 1 Grace Mariano.
Patuloy pa rin po itong pagdinig ng Senado kaugnay dito sa pagpapalaya sa mga convict sa ilalim ng GCTA law. Samantala kanina ay isinugod sa Manila Adventist Medical Center itong si Ginang Iluminada Gomez. Siya ang ina ni Alan Gomez na isa sa mga pinatay ni dating Kalawan Mayor Antonio Sanchez. Sa pagdinig, habang siya'y dumadalo sa pagdinig, tumaas ang kanyang blood pressure kaya agad siyang dinala dito sa clinic ng Senado. Pero mataas ito kaya isinakay siya sa wheelchair at dinala na po sa ospital. Ngayon, balikan natin ang pagdinig. Ang maririnig ninyong nagtatanong ay si Senate President Tito Soto III at si Bucor Chief Nicanor Paeldo naman po yung nagsasalita mula sa hanay ng mga resource person.
So, what are the other possible remedies aside from going to the Supreme Court?
I do not think that ordinarily if the person has not yet been released, a petition for declaratory relief may be filed with the Regional Trial Court. Other than that, since it's a fait accompli already, Mr. Senator, it's really more of a petition for certiorari and prohibition under Rule 65 of the Rules of Court.
I agree po, but of course they can invoke Department Order 953 because sa paragraph 2 nakalagay doon, basta reclusion perpetua. Remember, it doesn't even mention heinous crimes. Nakalagay lang, basta reclusion perpetua, dapat yon upon the prior approval of the Secretary of Justice. And most of these cases, if not all of these cases, kaya nga reclusion perpetua, heinous crimes. So it follows that all 816 or 1,914 na na-release pwedeng interpret na mayroong grave abuse of discretion because it is beyond their discretion to release those convicts without prior approval ng Secretary of Justice.
Precisely, the remedy is one for certiorari and prohibition on the ground of excess of jurisdiction or lack of jurisdiction. So if the same was done without the prior approval of the Secretary of Justice as mandated by that department order, then it can be viewed as lack of jurisdiction, there being no prior approval, or excess of jurisdiction for the reason that they exceeded the bounds of their authority in making a release without the prior approval of the Secretary of Justice. Either way, the net effect would be to nullify.
Mr. Chairman, with the permission of the Senate President,
The Majority Leader is
just to interject,
the permission of the Senate President. Of course.
yes, to follow your line because it will be difficult for me to come back. I'm number 11, but this is the point that I'd also like to make to support the Senate President's point on this, Mr. Secretary. Similar to a quo warranto case, we're all familiar with quo warranto cases. This is like a quo warranto case. Nagkamali yung recommendation, nagkamali yung dokumento sinubmit, in-appoint, and therefore mali yung proseso at natanggal. Similar to a quo warranto case, can't we not intervene this way? That the process, as you see, is very flawed. They failed miserably in the conditions for pardon, and they also failed in the process as other people were signing on behalf of the Undersecretary Faldon and maybe in all the others in the previous years. Can't we not also invoke similar to co-warrant proceedings and therefore recall these prisoners? Because, Mr. Secretary, this is tainting our administration's fight against criminality. This is the cornerstone of the president. So just that interjection, Mr. Senate President, I hope you don't mind, because that's the point that I raised also with Senator Drilon. Well, isn't this similar to a co-warranto case?
Senator, if I may just make a brief reaction to your statement. It is analogous or similar to co-warranto only in the sense that certain people, PDLs, who committed heinous crimes are not eligible in the first place to be credited with any time allowances. All right, so to that extent, it is similar to co-warranto, but the proper remedy is not co-warranto itself, because we're not talking about a public office here. So, but the idea is similar. Not eligible to begin with. All right, but the remedy is not co-warranto, but application for certiorari and or prohibition.
Yes, the point of the majority leader is he means it's analogous.
Yes.
As analogous.
May
With
I
the permission
ask-
of the chairman,
Just one point. I invite the Secretary of Justice to examine the case of People versus Tan. This was decided on February 25, 1967, where the facts are similar to this. In that case, Tan, the defendant, the accused, was released by provincial warden on good conduct time allowance. There was an error found by the court. The fiscal moved to rearrest the accused. The court allowed the on good conduct time allowance. There was an error found by the court. The fiscal moved to rearrest the accused. The court allowed the rearrest. So in this particular case, the rearrest of those 1,914, if found that they were in violation, that the release was in violation of the law and the rules, they can be rearrested on the authority of People versus Tan. May I request the Secretary of Justice to review this case? It's GR number L21805, dated February 25, 1967.
We shall take a look at that jurisprudential ruling, Senator.
I think may jurisprudence na eh. Oh, anyway, so just two more very small questions, but very important.
I joined the minority floor leader in taking a look at that case, because I think I've always maintained that you can rearrest based on an act that was based on false pretenses or false law or false implementation or interpretation of the law. Go ahead, please.
All right. Now, in the case of the one in Davao, Chief Superintendent Faustino, you were not able to tell us, to tell Senator Lacson, what was the loyalty that that particular guy did to be released? When he was released on special time allowance loyalty. Ano yung ginawa niya?
Because of to keep credit during the time of Yolanda, because at that time he was confined at Leyte Regional Prison, and following the case of Yolanda, he was also credited of another 2/5 for the fire that caused the destruction of Leyte Regional Prison.
So, hindi tumakas?
Yes, sir.
Mabalik or mabalik. Okay.
That is provided for in the law. Hindi siya tumakas.
Yes, sir.
Alright.
That's a new provision in 10592, sir.
One final question. This has been bugging many people that have gotten in touch with me. To the Bureau of Corrections, and I hope the Secretary Guevara will pay close attention. Who is Roberto Traya?
He's an employee of the Bureau assigned at the documents section, Your Honor.
He is the Assistant Chief Document Section of the Bureau of Corrections, correct?
Yes, Your Honor.
All right. He was killed
Yes, Your Honor.
August 27.
Assassinated.
Yes,
Assassinated. Yes. Right?
Yes, Your Honor.
Very near the Bureau of Corrections or NBP, right?
At the poblasyon.
Gumugulo ang kaisipan ng marami because if you will look at the matrix ng procedures ninyo, document section, doon nagsimula itong mga release orders. Merong co-compute yung GCTA, tapos drafts ng memo, ida-draft nila yung memo, papadala sa Director for Security and Operation, papadala sa Office of Director General, and then sa Legal Officer, re-review yung draft memo, then the Director General signs the memo. If the Director General is not available, a designated duty general are authorized. Then it goes back to the Office of the Director General. It is scanned for the record. It goes back to the document section, and the record section na kung saan nagtatrabaho itong si Roberto Traya na inassassinate. Sino pumatay dito kaya? Ano bang tingin ninyo nangyari dito sa tauhan ninyo? Sino nagpapatay? O sino nagpapatay? Meron bang na-displace ito sa corrections or sa mga preso or
Based on the initial investigation, sir, 3 years ago, he was ambushed in Leyte because he used to be assigned in Leyte. Because he's also in connivance with a PDL that was recently also napatay na rin. So, that is, dito yung lumalabas na yung nagtangka sa buhay niya sa Leyte ay mukhang yun pa rin. And then the PDL na nahuli naka-text niya ay namatay na rin, pinatay din the same day. But yung PDL na yan ay nandun sa ibang lugar, sa Leyte. So lumalabas na sa initial investigation, dalawa silang pinatay. But nung araw na yun. And the reports is ito ay inambus na rin yung 3 years ago, kaya nilipat dito sa Manila, sir. But I cannot divulge further the investigation because it's still ongoing, but that is what the PNP and our internal investigation is leading to, Your Honor.
because of the recent controversies surrounding the Bureau of Corrections, I think it's just but proper, Secretary Ibarra, for the NBI to investigate thoroughly and get to the bottom of this ng malaliman siguro. Kapagkat yung tao Assistant Chief ng Document Section involved dito sa mga nire-release. Ma-assassinate 7 days after a so-called controversial release is done and which was not consummated. So perhaps we would await a report from you thereafter. All right? Thank you. Mr. Chairman, I will terminate at this point.
Just a follow-up, just one question. Who appointed this guy, Traya?
I will find out, sir, but he's a plantilla
I understand he
official.
was transferred by Secretary De Lima to Leyte. Is that correct?
He is from Leyte and transferred 3 years ago to NBP, Your Honor.
Was that because of drug relationships?
He was
Or
ambushed in
connivance or
Leyte.
whatever? Huh?
Yes, sir. He was ambushed in Leyte 3 years ago. I still have to look for the motive of the ambush, Your Honor, but the initial investigation is that he is connected to some PDL inside Leyte,
Connected to the?
to some prisoners, PDL, prisoners deprived of liberty.
That is in connection with the killing by of the mayor of Albuera, Espinosa, and I understand from the General Elizar that they're investigating that angle because somehow he was involved in that in some drug operation. That's why I'm asking who appointed him and who transferred him back.
He was assigned lately for a long time, and then after the ambush, 30 years na daw po siya doon, and then 3 years ago he was transferred here, Your Honor.
All right, just to be sure, the NBI will look into this, right, Mr. Secretary?
We are contemplating of referring the matter or endorsing the matter to the National Bureau of Investigation.
Well, Attorney Dante Gran of the NBI, I just have one question. Are you looking into this matter?
Thank you, sir, for asking the question.
You're welcome.
Even before
That's my job.
the very good Secretary of Justice, my boss, has ordered us through what we call this DO or Department Order. We have started intelligence gathering about the killing. And we have good information. We call it a crime story. We have 2 or 3 angles about this. Something that we cannot divulge at the moment.
I will call Senator Tolentino, but I just have a comment. This is, again, a riding in tandem murder, right? Yes?
Get of us.
Are you answering yes?
Yes, sir.
Okay, that's good. Okay, thank you. Go ahead, Senator Tolentino. May nakuha ba kayo plate number, sabi ni Senate President? Kayo nyo ng malaking plate number, so wala naman nakuha. Ha? Kali na plate number o walang plate number? Ba't ba tao ba ito? Go ahead.
Thank you very much, Mr. Chair. I'm addressing to my former cabinet colleague, Secretary Guevara. Senior mo naman ako sa law school. We've been trying to help this committee by providing us some recommendations, but pinatay ito ni Sanchez. So you've been trying to give some recommendations to this committee, but I'll try to extract some recommendations from you in a friendly manner, Secretary Guevara. But let me revisit again the important timelines insofar as the core of the questionings might be concerned. May 24, 2013, the Bucor law was passed. And under questioning by Senator Drilon, you mentioned a while ago that you do not have any supervision insofar as regulatory and quasi-judicial resolutions issued by the Bucor is concerned. You don't have to answer this. GTCA law was passed May 29, 2013. The IRR was approved March 26, 2014. Or after a year. The new manual, which you have been citing several times, was approved by the DILG and the DOJ December 1, 2017. Correct? Siguro next hearing, Mr. Chair, I propose that the DILG should also be present here. Ikaw pala. Sorry. The Supreme Court decision concerning the PDLs versus Secretary de Lima was promulgated June 25, 2019. And apparently, the uproar came after June 25, 2019. I was surprised while seated and listening to you, Mr. Secretary, that you have been in a rush to modify the joint manual on GCTA issued by the DOJ and DILG. Am I correct? Yes or no?
Yes, that is correct.
Has it occurred to you, Mr. Secretary, that in our scheme of lawful order, we should have first law, which is the GCTA, and under that would be the IRR, the implementing rules, and under the implementing rules probably would fall the manual, the joint manual issued by the DOJ and the DILG. Am I correct?
That is very correct, Senator.
Now, what I'm saying is this. Secretary Drilon questioned you several times concerning your administrative, quasi-judicial supervision over Bucor. Sabi mo, wala kaming kapangyarihan doon. Let me refresh your memory. We took in law school Executive Order, is it 297, the Administrative Code of the Philippines, which under Section 22 gives you blanket authority to revise, modify, rectify abuses of maladministration, etc., coming from an attached agency such as the Bucor. Am I correct?
That is correct, but I have to qualify my answer, Senator. That is a general law, and there is a specific law on the Bucor. So in case of disagreement, not disagreement, but potential or apparent conflict, the specific law will have to prevail over the general law.
Mr. Secretary, kanina pinag-usapan, sinasabi nyo, apparently there is a conflict. The chair mentioned absurdity insofar as Section 1 and Section 3 of Republic Act 10592. Hindi po kaya tama ito? Kayo naman ang i-guide namin ngayon, Mr. Secretary, na panahon na para gumawa kayo ng amended IRR. Especially Section 4, which has been invalidated by that recent Supreme Court decision.
Exactly, that is what we are.
Yung po yung tanong ko, bakit inuna nyo yung joint manual kaysa doon sa IRR? Mas nauna po dapat yung IRR na baguhin natin. And if you're saying that you are now preparing an IRR, modified, amended, to comply with the Supreme Court decision, I ask the Honorable Chair to provide us a draft tomorrow. Yung Section 4 lang, inawala yung prospectivity. Sinabi ng Supreme Court, retroactive na. Can you provide that? This committee tomorrow, Mr. Secretary. Yung wish list mo, I'm sure, as a good lawyer, dali naman isulat yan, dami mong undersecretary. Ano ba yung dapat ilagay dun sa bagong IRR? Pursuant to the Supreme Court decision, it should have a retroactive effect, and even your wish list. Yung sabi mo, yung heinous crime, wala doon, pwede mo na sigurong ilagay doon para itong committee ito at yung iba't ibang committees na mag-handle ng pending bills dito sa Senado ay mag-guide kami kung ano yung aming gagawin. Paano ilalagay yung heinous crime, paano mo i-harmonize yung Section 1 at Section 2. Can you do that tomorrow, Mr. Secretary?
The subject of the review, the joint review, is not only the guidelines being followed by the Bureau of Corrections or by the Bureau of Jail Management and Penology, but the very IRR itself. The only thing that we cannot change or amend is the act itself, the law itself.
I agree. But we are referring to your wish list a while ago na nando naman sa 105 to Section 1, yung nabanggit, yun, alam nyo, kanina nabanggit na yung Department Order 953 yung sinasabi nyo wala sa batas. Napalagay na natin doon sa 953. So whatever is your wish list, provide this committee tomorrow para nang sa ganon, yung mga pending bills, alam din namin kung saan kami mag-harmonize at magpo-propose ng amendments. Because you've been guiding us for several hours, now try to guide us direct to the point now, Mr. Secretary.
The Joint Committee was given 10 days to complete its study and recommendations. I am not prepared to say that we can submit something to you tomorrow.
Mr. Secretary, so you're now saying that the Joint Committee will prepare an amendment to the joint manual as well as the IRR?
Yes, that is the very subject of the joint DOJ, DILG order.
But let me refer to you, and for the benefit of this committee. Alam niyo po, kanina pa natin pinag-uusapan itong joint manual. Kapal nga nitong binabasa ko kanina. Alam niyo po, tatanungin ko si Yusek File doon. Bukod po doon sa joint manual, there is a prison manual crafted by the DOJ during the time of Secretary Toquero. Siya yung DOJ Secretary. And ang prisons director is General Sistosa. And I'm sure that prisons manual is still in operation and valid. Am I correct, Mr. Secretary? Kasi nagkakahalo-halo na tayo dito sa, this joint manual is just for the GCTA. The prison manual is for the general operations of the newly built prisons. Ano yung prisons discipline? Ano yung medical benefits nila? Ano yung clothing requirement nila? Ano yung food requirements nila? Security requirements, etc., etc. Am I correct?
But that is correct.
Kasi ngayon naghahalo-halo to eh. So hiwalayin natin yung joint manual doon sa prisons manual. And you will agree with me, tapos na yung prisons manual, baka naman pwedeng i-provide sa committee tomorrow yung prisons manual for us to be guided accordingly.
The Bureau of Corrections has informed me that that prisons manual is still in effect.
Yeah. So may I, Mr. Chair, may I request that the Bucor head, the Secretary of Justice, provide this committee tomorrow sa continuation ng hearing ng prisons manual.
Yes, Your Honor.
I tend to agree with you, but I just want to make sure I don't want to make a dishonest man out of the secretary. Can you do it tomorrow?
The submission of the prisons manual?
Yes.
Yes, sir.
It's already existing. Di ba?
Yeah, it already exists. And if only we had it today, we could have given this to you right away.
Thank you, Mr. Secretary. Mr. Chair, kaya ko po sinasabi to. Kasi yung daily activities, correct me if I'm wrong, Yusek Faldon, yung daily activities sa Bilibid. Meron tayong overseer. Ito yung foreman. Yung foreman, siya yung in charge doon sa mga facilities. Minimum, medium, maximum, and the RDC, yung reception. So siya yung in charge. Ang balita sa akin, tatlong shifts. Yung overseer, ibibigay niya yung report doon sa superintendent. Am I correct? So you have 3 shifts of superintendent. So nagsimula tayo sa overseer. I-report kay superintendent. Ito po yung pang-araw-araw na gawain nila kung talagang merong good conduct talaga ito. Am I correct, Yusek Faldon? Yes or no?
Yes, Your Honor.
Si superintendent ngayon, 3 shifts, nagre-report naman siya dito sa papunta doon sa Records Division na nabanggit ni Senate President na yung isang tauhan ay pinaslang noong August 27. Tama po ba yun?
Documents Division, Your Honor.
The Records Division is the same as the Documentation Division. Pareho po yan.
Yes, sir.
At si Records Division.
You're on your second 5 minutes already, but
Just 2 more questions, sir. 2 more questions.
Wrap up this.
Si Records Division ang magre-report naman doon sa MSEC. Tama ba?
No, Your Honor.
Saan siya magre-report? Sa Director General na?
No, sir. There's a time allowance
Committee?
supervisor.
Okay.
Yes, sir.
So what I'm saying is this. The final approval whether that PDL is in compliance with good conduct, time allowance, etc., rests on the Director General. So kaya ko po sinasabi to, Mr. Chair, parang lumalabas po sa ating pag-aaral when you compare pardon, parole, executive clemency, lahat po ito dumadaan sa masusing proseso at lalong-lalo na yung executive clemency, presidente pa ng Pilipinas ang nag-a-approve, usually binibigay pag Pasko, nakapublish yung mga pangalan sa dyaryo. Dito po sa GCTA, wala po napapublish dito. Kaya po sinabi ko noon, kahit sa website ilagay. So that's why I'm requesting the Secretary of Justice, when we amend the IRR, because it should have been triggered since June 25 by that Supreme Court decision, isama na po natin lahat yun sa wish list. Can we do that? Kahit hindi mo masubmit bukas yung wish list mo, Secretary Guevara.
We will recommend the inclusion of a provision of transparency not only in the IRR but also in any proposed amendment of the law itself.
Salamat, Mr. Secretary. One last question, Mr. Chair, addressed to, with due respect, Mrs. Sarmenta. One last question. A few weeks ago, when this brouhaha concerning the release of former Mayor Sanchez was raised, you were quoted in a television interview or even a newspaper report, radio interview, that because of this incident, pabor po kayo sa restoration ng death penalty. Tama po ba yung pagkakaintindi ko, Mrs. Sarmenta?
Opo, at that spur of the moment, I said, yes, I agree to restoring the death penalty. But then, when I thought it over po, being a Christian, I would rather have the life sentence, because in the death penalty, it's only one injection, tapos na, tulog na siya, he's done. But in the life sentence, the prisoner would be given the chance to, to be reformed also. And also, the mere fact that he suffers, he should be suffering for the crime that he did. Mas gusto ko pa yun, makita na nag-suffer siya. Hindi naman ako sadista, but then, parang mas maano sa loob mo na yung kanyang hatol ay panghabang buhay.
Maraming salamat, Mrs. Armenta. Philippine Society commiserates with you, and I'm sure a lot of things will come out of this committee hearing. I yield the floor, Mr. Chair.
Thank you.
Thank you very much. Just an advice to the new senators, and this is not meant to disparage. Try to shorten your questions because the time is eating your questions. The time you lay the predicate takes too long, and so. But that's why we gave you another 5 minutes. Thank you. All right. We now have Senator Marcos. Please go ahead.
Yes, thank you very much, Mr. Chair. I am puzzled by the number of manuals that have been mentioned. Nabanggit na ni Tol kanina, ni Senator Tol, na may prisons manual. Tama po ba? Na nagmula pa nung panahon ni Secretary Tuquero. Pero rin binabanggit si Attorney Reynante Orseo na uniform manual kasi hindi daw magkapareho yung sa BJMP, yung Bucor at saka yung NBP. Bakit may kinailangan pang ibang manual?
Kasi po, yung pong manual na ginawa namin, hindi na naman po yung sa process ng pagbigay ng GCTA, kundi yung process o paano mapupunta yung mga kalpeta ng inmates from the BJMP or Bucor going to the...
So kailan nagsimula yung pagsasaliksik ng uniform manual na naman? 2016 po ba?
2017 po namin ginawa.
2017
yes, po.
Ang pag-uumpisa nito. At doon sa uniform manual, pinagkaisa yung interpretasyon ninyo na kada buwan babawasan ng 25 days. Depende sa tagal. Ganun po ba?
Ganun po. Depende po sa tagal ng...
Kasi yun ang tinutukoy ng lahat na nagsimula dyan yung good conduct computation. Doon sa uniform manual na ginawa ninyo noong 2017.
Hindi po, just to be corrected, yung pong IRR, nasa batas po yung number of periods.
Hindi nga po kasi nga yung bilang sa batas hindi maliwanag. Nasasabi, first 2 years,
yes,
binibilang ninyo kada buwan. Hindi kayo nag-iintay. At ang tinutukoy, itong uniform manual na ginawa ninyo.
Meron pong ganun sa IRR na ginawa po dati ni Senator De Lima.
Pero alam naman po natin na hindi tinanggap ng Supreme Court yung IRR sapagkat nagka-problema sa retroactive effect, hindi
yes,
po ba?
Ang nag-i-issue lang po doon, yung prospectivity ng law, but then the whole IRR is still in effect.
Pero maliwanag dito, first 2 years, pagkatapos 3rd to 5th year. Ang bilangan po, ayon kay Apo Faldon, first month, bawas kagad. Second month, bawas kagad. Parating umpisa sa zero
Ang idea po kasi nung paano ka magbabaw so magdadagdag, kung halimbawa in a month's time, there is a single violation, for that month alone, wala kang DCTA dapat. For the whole month yun.
Hindi kaya nga, pinagtatakan lang namin, bakit naisip ninyo gumawa pa ng bagong manual? Kasi meron na naman dati. Bakit binago pa?
Hindi po binago. Ginawa po kami ng operational manual para pagkaroon ng uniformity ang ginagawa ng process ng BJMP at saka ng Bucor.
Ang sabi po kasi, wala naman daw uniform manual dati.
Wala.
Kanya-kanyang manual yan.
Tama po.
Bakit naisip ninyo gumawa pa ng panibago?
Kasi po,
para makinabang yung mga VIP po?
Hindi ho. Kasi nung ako naging undersecretary, nagkaroon po ng issue paanong nata-turn over in documents yung prisoners doon sa papuntang Bucor at papunta sa Boards of Pardons and Parole at even doon sa PPA up to the level ng paano na-approve ng Presidente. So may mga ganun pagdatali mga agency. So
Naipalathala po ba itong manual na to?
Opo, nasadyari po yan.
Na-publish
Yes po.
ng kompleto?
Yes po.
At kailan ho na-publish yan? Pwede makita yung sample
mga
ko.
December of 2017. Yes.
Pwede nyo dalhin?
Congress o DOJ?
Sino
Nasadyari
nag-publish?
po, newspaper po.
Sino nag-publish?
DOJ po.
Oh, hindi Congress.
Ay, di po.
Oo, kaya nalilito kami eh.
Sorry.
Oo.
Sorry.
Parang kasi gawa lang ninyo yan eh. Alam ko naman sumusunod kayo doon sa Tanyada versus sa Tubera.
Yes.
Alam naman natin na kapag may penalty, dapat i-publish.
Yes.
Kaya nais namin makita kung paano at bakit kayo nag-isip na gumawa na naman ng ikatlong manual.
Ikatlo wala pong...
Ikatlo, kasi sabi mo, BJMP, pakatapos may Bucor, tapos may panibago
Hindi
pang
po.
uniform manual.
Hindi po, kasi yung view ko, nung ma-implement po yung batas, because a mandate was given to BJMP created its own procedure. So yung view ko has its own procedure. Ang problema po sa dalawang procedure, hindi nag-harmonize. So what we did is just to harmonize the two procedures. That's what we did only sa uniform. That's why we called it a uniform manual.
Pero hindi ba sa pag-harmonize na procedure, gumagawa kayo ng panibagong batas?
Oh, wala po. Wala po. It's more than operational procedure lang po yan.
Pero
Wala
hindi
po.
yata operational yung pagbibilang ng 25 days kada buwan.
Nasa batas
Baka
po
bago yun eh.
Actually,
Hindi,
kung,
yung article 3, yung section 3 po, hindi naman ganun. Yung article 97, iba yung pagbibilang. Hindi. Alam natin na may problema po itong batas na to. Klaro naman po yun. Sabi ni Secretary Guevara kanina, nahihirapan sila mag-harmonize. Yung section 1, dapat kontrole yung last paragraph kung saan nandun yung exclusion ng mga heinous crime. Sa palagay ninyo, yung declaratory relief o di kaya yung sinasabi nga, yung section 65 na certiorari, makakatulong. Dahil ang takot natin, kapag challenge itong batas na to, maaaring maging unconstitutional. Si Secretary Guevara po ba naniniwala na maaari dahil napaka-vague, ika nga, at walang maayos na definition yung good conduct, Secretary po?
Yun pong definition ng good conduct ay, in my opinion, may sufficient guidelines to go by. But it's really the more fundamental question of whether those convicted of heinous crimes are entitled to the benefits.
Given that Section 1 only refers to preventive imprisonment.
Yes, although it's under that heading, preventive imprisonment time credit.
The final
however,
paragraph.
the sentence says excluded from the benefits of this act.
Yes,
so
po.
that means all benefits, not only on preventive imprisonment time credit.
Yes, may I similarly manifest to the chairman and the rest of the members of this committee that this law, if challenged in the Supreme Court, could be considered unconstitutional for its vagueness, for the lack of clear definitions on good conduct, and also for the apparent lack of definitions for the length of time for one to be considered of good conduct or not. Hence, it is important that it come back to us for further legislation if we in fact believe in the intent of the law, and harmonizing as we see it from the former DOJ and the existing SOJ will no longer be so difficult. Ang pinakamahirap po dito, yung GCTA for sale. Ang inaalala ng lahat ng tao, for sale daw ang GCTA, ang SPAL nabibili. Handa po ba kayo na pumipirma si Chief Superintendent Faustino at yung iba pa, si Yusek Faldon? Handa po ba kayo na mag-lifestyle check para doon sa napaka-high profile drug cases na pinalabas?
Yes, Your Honor.
Yes, Your Honor.
Okay, so Mr. Chair, handa po daw sila. Siguro magpa-follow up ang aking mga kasamahan. At sana ibigay po lahat ng mga manual na yan, yung uniform, yung BJMP, yung Bucor, at iba pa, yung prison manual, para maintindihan po namin, sapagkat itong mga manual na to ay hindi lamang mga reglamento para sa operation na sinasabi ninyo, kundi may force and effect ng batas. Salamat po.
Okay, thank you very much for the
Mr. Chair.
question.
Mr. Chair.
Yes.
Just reiterating the presence of the ILG at this session, since Senator Francis Tolentino in good faith mistakenly thought that we're absent.
No, you're present. You just got your 30 seconds worth of pain. You better thank Senator Tolentino for that because he allowed you to have your 30 seconds worth of pain. All right? Biro lang. Anyway, we shall now have Secretary The Rock. But I think he's going to give way to
Mr. Chair, I would like to yield my
the feminine of Bonga.
to Senator Bongo. After him na lang ako.
Feminine nga ng Bonga eh, Bongo. Oh, maskin ko. Hindi, nagkukuha sila eh.
Magandang hapon po sa inyo lahat. Gusto ko lang pong linawin na hindi tayo nandito para magsisihan, nandito tayo para ayusin ang sistema at siguraduhin na hindi may pagkakait ng hustisya para sa mga biktima ng krimen. Welcome po ang investigasyong ito para malaman ng tao ang totoo. In fact, pabor po si Pangulong Duterte sa investigasyon para malaman natin kung saan ang mga lapses at kung may kailangan managot sa nangyari. Kailangan natin silipin at linawin ang mga probisyon ng Republic Act number 10592, pati na rin po ang implementing rules and regulations nito. Sa ngayon, nagmumukhang iba-iba ang interpretasyon ng batas at may mali sa application ng batas na ito. Pero ang malinaw para sa akin at sa mga ordinaryong Pilipino, hindi tama ang isang high-profile convict na pinatawa ng 7 reklusyon perpetua dahil sa karumal-dumal na krimen at nahulihan ng illegal na droga sa loob ng bilangguan ay bigla na lang mapalaya. Maaring maganda ang layunin ng batas na RA 10592, maganda naman ang mayroong mga insentibo para sa mga gustong magbagong buhay, pero dapat siguraduhin natin kung sino man ang mapalaya sa batas ay yung qualified talaga sa good conduct time allowance. Alam rin po natin na kahit anong good behavior sa kulungan ang gawin ng isang kriminal na nag-commit ng heinous crime, hindi nito maibabalik ang buhay na nawala. Hindi dapat maging polisiya ng gobyerno na mawalan ng hustisya ang mga naging biktima ng mga kadumal na krimen at mapalaya ang mga kriminal na may pagdududang maaring maging banta at salot muli sa lipunan. Sa aking pananaw, kailangan nating suriin ng mabuti ang pinanggagalingan ng aplikasyon ng batas na ito. Sino ba ang nagsulat at nag-aproba ng implementing rules and regulations na nagsasabing kasama ang mga convicted sa heinous crime sa computation ng GCTA? Bakit ba ganyan ang application ng batas? Kailan pa ba yan ginagawa? Saan ba ang mga lapses sa implementasyon ng batas o sa itinakdang polisiya mismo? Kung kailangan amendahan ng IRR o maging mismong batas, gawin natin. Suportado ko ang panukala ito sa Senado para amendahan o maklaro ang batas na ito. Pangalawa, paano naman maging good behavior ang pagpupuslit ng shabu at marijuana sa loob ng bilangguan? Ginagamit pa ng estatwa ng Birhen Maria para magtago ng shabu. Ang mga taong gumagawa nito ay walang konsensya at walang takot sa Diyos. Good conduct ba ito? Paano ba nakukonsidera na good conduct? Ano ba ang mga kwalifikasyon? Gusto natin malaman ang mga implikasyon sa GCTA kung magkakaroon ng prison violations ang mga inmates. Pangatlo, bisitahin natin ang kasulukuyang estado ng ating mga bilangguan. Dati ginagawa ang illegal na droga mismo sa loob ng kulungan. Ngayon, sinasabi natin hindi na. Ano ba ang status ng illegal drug clearing ng Bucor, ano ba ang ginagawa ng Bucor para tuluyang mawala ito? Panghuli, sa tingin ko po, kung tatanungin ninyo ako at ibang senador, hindi kami sang-ayon sa pagpapalaya sa mga convicted heinous crime, kaya may iilan sa amin na sinusulong maibalik ang death penalty. Tulad ni Pangulong Duterte, galit po kami sa kriminal, lalong-lalo na po involved sa heinous crime. Consistent kami sa stand na yan. As legislator, it is important for us to make sure that there are no dubious provisions at contentious issues in the application of our laws. Ang layunin natin dito ay siguraduhin may hustisya sa ating bansa. Our laws should provide protection to our innocent people and justice to victims, and not provide a sanctuary through a law that benefits perpetrators of heinous crimes. Huwag natin ipagkait ang hustisya sa mga biktimang nangungulila dahil lang sa isang batas na salungat sa hustisya ang ating inaasam para sa bawat Pilipino. Death is better than being in jail until you die. Kung ganon katigas ang Pilipino, then ibalik ang death penalty. Kung gusto nila humanitarian, we have to implement this law. But ayusin lang, we can't have both. Mr. Chair, with your indulgence, allow me to ask the following questions. At meron na po akong gustong ibahagi kasi po para maintindihan po ng publiko.
With all due respect, Senator Go, your 5 minutes is up, and I'll give you 2 minutes to ask your questions.
Okay. Ito lang pong, Mr. Chair, gusto ko lang po sanang i-emphasize that our President Duterte exercises prudence in deciding cases and petitions for executive clemency. Binubusisi niya ang lahat ng dumadaan sa kanya for his approval. Hindi po siya padalos-dalos at pinag-aaralan niya ng mabuti ang lahat ng dumadaan sa kanya. And in fact, nasa lamesa pa niya ang iilan pong humihingi ng mga executive clemency or pardon. At pinapabalik niya, humihingi siya ng narrative. Qualified ba ito? Sino bang mga ito? Matanda na ba ito? At deserving na ba silang lumabas at lumaya? So ibig ko pong sabihin, kung ganun po kasigurista po ang ating Pangulo, so dapat rin po sa mga kasama natin sa gobyerno, sa Bucor, sa DOJ, ay pag-aralan po nating mabuting, lalong-lalo na po yung mga involved po sa heinous crimes. So, nakikiramay po ako kanila, Mrs. Sarmienta, Mrs. Gomez. Alam ko pong hindi na po may babalik ang buhay ng inyong mga anak. Anyway, bago po pumutok itong balitang ito, gusto ko lang pong sabihin sa inyo yung totoo. Sir, bigyan mo naman ako ng additional 5 minutes. Sila kanina, 20 minutes eh.
The chair is always very fair.
Thank you, sir.
That's why I even cautioned Senator Tolentino that your questions should be brief so that your time will be well spent. Because we do not count the answers.
Thank you, sir.
But I was looking at Senator Pangilinan because he might ask you, will the gentleman yield? Because that was a privileged speech that delivered.
Thank you, sir.
Thank you. Okay.
Minus na lang bukas po.
I will allow you. Go ahead. Ask your question.
Bago po, ikwento ko na lang po, bago po pumutok yung balita, maalala ko, August 20, nabasa po natin sa mga periodiko ng possible release of Mr. Sanchez. Then nung araw-araw po merong presidential briefer na binabasa ang ating Pangulo, including confidential ones, ay nung August 21 ng gabi, nabasa niya po ito at unang-una niyang ginawa, pinatawagan niya kaagad si Bucor Chief Faeldon at Ma'am Mrs. Sarmienta, sinabi niya kay Bucor Faeldon, sabi niya, do not release. At ang sinabi niya, order from the higher authority. Hindi niya muna pinangalanan, pero ibig sabihin, sino bang, wala naman pong ibang higher authority other than the President of the Philippines. Yun po yung sinabi niya at pinarating rin po kay Secretary Guevara na hindi po papayag si Pangulong Duterte. In fact, sinabi ko nga kay nagbigay na lang po ako ng statement na sabi ko nga kay Mr. Sanchez pagdusahan at pagbayaran mo na lang po yung kasalanan mo dyan sa loob kesa lumabas ka, baka ikli pang iyong buhay. At sabi ko nga, mas mabuti pang antayin mo na lang na si San Pedro na lang ang pumatol sa iyo, Mr. Sanchez. Anyway, tuloy-tuloy po ang kampanya ni Pangulong Duterte laban sa kriminalidad. Sama po kami rito at asahan niyo po sa mga naging biktima, hindi po papayag si Pangulong Duterte na gano'n na lang po, basta-basta. So, sabi ni Pangulong Duterte, magkakaroon rin siya ng sarili niyang investigasyon at gusto niyang malaman kung meron bang korupsyon na nangyari. Bakit po na-release ang mga prisoners na involved po sa heinous crimes. And then after dagdag ko na lang po to, after the GCTA law was enacted in 2013, then DOJ Secretary De Lima and DILG Secretary Rojas caused the issuance of the corresponding IRR. Did they not? I'm addressing my question to DOJ. In the said IRR, Secretary De Lima and Secretary Rojas did not include a rule or guideline categorically stating that heinous crime convicts were not covered by the benefits of the GCTA law. Is that correct? And then, are you aware of any incidents of corruption in the grant of GCTAs? Kindly explain. And then last, what remedial steps do you think Congress should take in the light of the present controversy over GCTAs? Yun lang po ang aking tanong. Yes, sir.
Thank you, Senator, for asking those questions. First of all, as I mentioned earlier, the implementing rules and regulations that were adopted in 2014 followed closely the wordings of the law itself. So as there was no very explicit and express statement that would clearly indicate that heinous crime convicts and those charged with heinous crimes are not covered by the benefits of the law. Since there is a doubt in the interpretation, nothing was also mentioned in the implementing rules and regulations to clarify that bit of ambiguity. So essentially, ganun din po ang laman ng IRR. So that's why we are trying to review this and inject our own view about the exclusion to make it even more clear whether that will in fact be sustained if questioned before a court of law is something that we cannot really anticipate. But that's how we intend to clarify these implementing rules and regulations by injecting a very clear statement that those convicted of heinous crimes as well as habitual delinquents, escapees, and recidivists are not covered by any benefit under RA 10592. Now, I'd like to take this opportunity, if I may be given the privilege by this Justice Committee to make certain recommendations insofar as the law itself is concerned, because this is the main reason why I attended this particular hearing. Not so much to answer operational questions as to provide somehow a legal framework for any possible legislation, remedial or otherwise, that Congress, both the Senate and the lower house, may deem proper. So
well, let me remind the good secretary that this committee, particularly the Justice Committee, is interested in addressing the problem by creating legislation. In fact, we have already filed a bill. Several bills have been filed by the Senate on the matter. And that's why your statements would be welcome. The Blue Ribbon Committee is also in aid of legislation, but principally to weed out corruption and to find out whether there was malfeasance, misfeasance, and nonfeasance. And I'm glad that the President is very, very aware of this, and he was immediately on the act, according to Senator Go. But what is most important is the fact that if the President was really, kung totoo talaga siya mismo, ay ganun kasintindi ang kanyang galit dyan, bakit napapayagan, bakit nakakalusot doon sa Bucor yung mga bagay na ganyan? Kaya yan ang dapat nating address ngayon dito. Because una-una, you're aware, and I have a document here, in the permission of
Yes, sir.
go, where the application for clemency, for executive clemency was filed. And in my prefactory remarks, sinabi ko, dapat alam, in your experience, and I'll ask a question, in your experience, yan bang andito ang Bureau of Pardons and Parole, right? What is your name again? Dr. Bayang. Hindi ba niya sinasabihan ang Bucor pag nag-a-apply, halimbawa, katulad niya si Sanchez, na gusto niya ng executive clemency, hindi ba niya tatanungin ang Bucor kung okay ba yan, kamusta ang performance niya, maayos ba siya, may good conduct pa siya, di ba niya tinatanong yan?
That is included, sir, in the evaluation and investigation of the Board of Pardons for all cases, not only the exception.
So you get the input, sir, of the Bureau of Corrections?
Yes, sir.
And who would that be in the Bureau of Corrections?
The documents, the overseer, everything, sir.
The documents, and the guy who was handling documents had just been killed. At least some of the documents, right?
Yes, sir.
And would you ask the Bureau of Corrections, Director General, also for comments?
Actually, sir, the Director General is the one giving instructions to those who are involved in the reformation of inmates to report, to submit to
So tinatanong niyo sila?
Yes, sir.
Ang Bucor Deputy Director General, right? Tinatanong
Yes,
niyo?
sir. We asked him, sir.
So he would know na nag-apply ito for executive clemency. Correct?
Yes, sir.
At dahil mahigpit nga kayo, hindi nyo pinayagan na magkaroon ng executive clemency because in your words, na sinasabi doon sa executive clemency decision, because of the gravity of the crimes committed. And I'm glad the parents are here, Mrs. Armenta is here, na sinabi doon na, and they were informed also. Were you informed of that? No, you were not informed. But I guess they'll deny nga eh. Pero bago, kung kayo ay magsasabi na papayagan nyo, i-inform nyo ba yung mga offended parties?
Beforehand, sir, we we request them for comments. Yes, sir. We inform them and we will publish the names of these
Pero
people.
mukhang hindi kayo nasabihan, ho. Can you please speak to the microphone because I need your statement for the record. Hindi po kayo nasabihan.
There was no such information given to us.
Ito po yung sa application for executive clemency, hindi po doon sa GCPA.
We just came to know that he applied for executive clemency only when this matter came out.
When August 20 happened.
Yes.
So hindi na alam po. So maybe you can correct that, ano? Because talaga naman dapat ako rin na biktima niyan eh. Yung isang mastermind sa tatay ko kinomit yung sentence. Hindi namin alam, from death to life. Sama ng loob ko, kaya tinatanong ko kayo na, talagang nararamdaman ko yung pigati ng mga puso nito mga magulang. Pero ibig sabihin, kung naghigpit kayo, dapat alam na ng Bucor, alam na dapat ng Secretary of Justice siya. Bakit 6 months later, nagulat ba kayo na bigla lumabas ito si Sanchez dito? Irrespective of the law. Everybody should be on notice. Oy, hindi pinayagan niya ng or executive clemency. Hindi naman lulusot kay Presidente yan ba't pinayagan niyo sa Bucor? Tama po ba yan? Would that be a correct assumption?
It's correct, Your Honor.
And when that assumption is done, masisisi niyo ba ang tao na sabihin baka may milagro na nangyari dyan? Una-una, tahimik na tahimik, walang transparency, at ito ay talaga masela na kaso na dapat a normal person, a common sense person would know, teka muna, may itong kaso ito, na hindi pinapasok ng sa permission to clemency, dapat magtanong muna ako sa boss ko. Nagtanong ka ba? Tatanungin kita ulit. Nagtanong ka ba? Director General Paildon?
The Bucor is not part of the parole.
No, but they said you were consulted. Kinokonsulta kayo?
I am not aware of any application of
But sir, if I were running, question ba tayo, if I were running, lahat na mag-a-apply doon, makikita alam ako dahil sasabihin ko, huwag niyong i-consider yan dahil luko-luko yan. Ang daming rules na binabiolate. Pakita niyo yung rules. Andiyan, may checklist ako ng mga rules na binabiolate. So dapat, ayan yung mga meron siyang exchanging uniforms or wearing clothes other than those issued for the purpose. Maliit na bagay pero malaking bagay dito sa good conduct. Merong mga nagsasabi na keeping an unauthorized amount of money, jewelry, watches, cellular phones, or other communication devices. Luxury pa. So, yan lang. Hindi ko na dadaan sa lahat. Pag nalaman ko yan, hindi ko talaga i-recommend. Tama po ba yan? Would I be well within my premises to do that?
Your Honor, I would like to request the Honorable Member of the PPA that your answer to the Honorable Senator is wrong. We have nothing to do with the application of pardons and parole. You just get from our office the carpeta and you're the one to recommend
tatanungin ko
to
ulit
the
para
President.
malinaw.
So we have nothing to do with the recommendation of parole. So I would like the gentleman from the PPA to correct, Your Honor. Yes, sir.
Do not press your luck.
The carpet is with us, sir.
Do not press your luck. I'm going to help you with it. I'm asking him again. Dahil sinabi niya na nakukonsulta at sinasabi sa kanila ang Bureau of Corrections. Is that correct?
That is correct, sir. We consult these cases with the Bureau of Corrections because they submit to us the records of the PDL.
So sila nagsasabit
And
na
the
record.
contents of these records came from the Bureau of Corrections.
That's
So
correct.
we asked them.
So, kung di mo nalaman, bakit di mo nalaman?
The date is not my term yet, sir. When the application was
December 2018, it was denied and then
17,
it was
the
approved
application
February
was
17.
Yes, Your Honor.
Ah?
The application was 2017, Your Honor.
2018 December, and then it was rejected finally in February 17, 2019. You were there already.
The application, sir, was applied prior to my assumption, Your Honor.
That's right, but the decision was made 2019, and somewhere along the line, dapat nalalaman nyo kung sino nag-apply because meron ka dapat inputs doon. I'm not trying to blame you. I just want to make sure that in the interest of good legislation in the future, dapat, no uncertain terms, dapat kinukonsulta kayo sapagkat kayo nakakakita close quarters. Pangalawa, sasabihin ko na rin yan, since sinasabi ko yung close quarters, sasabihin ko rin sa inyo, nakikita ko close quarters, may telepono yung preso, tumutugtog doon sa, may concert doon sa preso, may mga kubol. So hindi mo maalis. It is up to us, kung tayo nang mamanayaw noon, hindi mo maalis sa sasabihin, some are more favored than others. Hindi mo masisisi ang tao, di ba? Kaya nga nililinaw ko ito, para sa pagdating sa legislation, malinaw na malinaw yan. So, sa madaling sabi, talagang hindi talaga nagbibigay ng inputs, hindi nabigyan ba kayo ng inputs dyan? Sa pag-application sa Executive Clemency ni Sanchez?
Hello, we received, sir, the carpeta, and in the carpeta, it includes all reports.
Ay, yung carpeta yan, ang laman ng talagang lifetime niya sa records, di ba?
Yes, sir.
Oh,
Yes, sir.
so dapat alam nila
Yes,
yun,
sir.
di ba?
Tama po.
Oh, ayan ang carpeta. Meron akong copy dito. Inago na naman ni Senator Dilo. Anyway, thank you, Frank. But anyway, the point is, dapat hindi makalusot dyan. Ang nagtataka na namin na Secretary General Paildon, Director General Paildon, is paano ninyo na i-recommend yan? Ang dami niyang violations. May drug, paulit-ulit na ako dyan. Ayoko na ulitin yan. Pero nakalusot pa rin. Nabigyan mo sila ng process. Meron pinakita si Senator Lacson, ang pirma mo. At ang dami rin nangyayari na pinipirma ng mga tao mo, yung hindi dapat nila gawin. Di ba? So talaga may problema tayo. So that is what I want to lay the predicate on. Because Senator Go has said the President is there, he's looking at the records, he will be very extra careful na hindi makakalusot yung mga bagay na ganyan. Is that correct, sir?
Yes, sir. May I continue?
And I'm asking you a question.
Yes, sir. Anyway, para po maintindihan ng...
What is the answer to my question? Hindi makakalusot kay Presidente.
Yes, sir, of course. In-explain ko na kanina, very prudent po ang ating Pangulo. Unang-una, para po maintindihan ng publiko, etong iba't ibang klase po itong pagre-release maraming nanonood sa TV. May probation, ito po yung simplify I will just simplify it. Probation, the court grants the probation. Itong parole, ito po yung dumadaan sa Board of Pardons and Parole. And then, they grant the parole. Ito namang good conduct time allowance, GCTA, ito po yung sa Bucor. Sila na po ang nagpo-proseso nito. Marahil nagtataka kayo bakit hindi po alam ni Pangulong Duterte yung na-release na almost 2,000 kasi po hindi dumadaan sa kanya. Ang dumadaan lang po sa Pangulo ay itong absolute pardon or conditional pardon. Now, my last question. If proven excluded po yung mga heinous crimes na na-release na po and not qualified sila, paano ho ba yun? Pwede ba natin silang i-recall? O pwede ba natin considered sila as wanted? O pwede bang shoot to kill? Anong pwedeng gawin sa kanila kung...
Senator, I already stated earlier that it's a very complicated issue. The Department of Justice has a view regarding how to deal with those who have already been released but were sentenced to life, or rather sentenced due of crimes which are considered heinous in character. But as I also explained earlier, considering that maybe constitutional issues may be involved here, and interests of both sides have to be considered and balanced, I'd rather not make a comment at this time until a more thorough study on how to deal with a problem has been made.
Okay. Sir, okay na po ako. Chairman, Mr. Chair, I'm done. Thank you po.
Inclusion interval here with Senator Dilo. I requested the records of the, that is what we were discussing here, of the Bureau of Pardons and Parole, or the board, my mistake, so that we would find out the records, no? Because napaka-importante yan, because one of the questions that we have is checks and balance. Walang checks and balance, yung Bucor, wala rin checks and balance dun sa provincial prisoners, sa BJMP. Would you agree, sir? I agree, sir. Thank you. I will get back to you later. In the meantime, my esteemed colleague, Senator Pangilinan, has the floor.
Thank you, Mr. Chairman. Magandang hapon po. I just have a few questions. Marami ng mga tanong na nasagot pero nais ko lang magtanong pa ng ilan para lang mas mapaliwanag pa. Nabanggit kanina ni Ginoong Faldon, ang ating Director General, na ang pinirmahan niya ay Memo of Release pero hindi release order. Tapo yun, di ba?
Memorandum of Release.
Yes, Memorandum of Release.
Yes, Your Honor.
Yes, Memorandum of Release. At ito ang tinatanggap ng superintendent at siya ang pipirma ng release order. Tama po ba yun? Yun ba yung proseso?
Yes, Your Honor.
Meron na bang Memorandum of Release na hindi sa ilalim ng inyong panunungkulan na hindi pinirmahan o ayaw pirmahan o ibinalik sa inyo ng superintendent?
No, Your Honor.
So in other words, administrative na lamang, wala nang discretion itong superintendent para pumirma o gumawa ng release order. Wala na siyang discretion. Susunod na lang siya doon sa Memorandum of Release.
Yes, Your Honor.
Okay. So hindi maaaring ibaliktad ng superintendent yung iyong Memorandum of Release order.
Yes, Your Honor.
So, ibig sabihin, kayo talaga po ang merong kapangyarihan at yung Memorandum of Release Order ay, kumbaga, yun ang susi. Yung release order ay susunod na lamang dun sa Memorandum of Release.
Yes, sir. That will trigger the processing of the release until the superintendent will issue the final release order.
Yes, okay. Dito sa Department Order 953, kayo naman ay familiar din po dito, Ginoong Director General.
No, Your Honor. It was just brought to me by the Secretary a few days ago, Your Honor.
Dahil ang subject ng Department Order 953 ay Rules and Procedure in the Release of National Prisoners with Expired Sentence. So bakit hindi ninyo alam itong Department Order na ito na saklaw ang pag-release ng mga ng mga national prisoners na mag-expire na ang kanilang sentence. Bakit hindi ninyo alam ito?
I asked our legal officers why I was not briefed about that department order. And I was briefed that there is a communication between the former Director General and the former Secretary of Justice amending that procedure, Your Honor.
Meron bang written issuance dito sa amendment na ito?
There's a letter that the Senior Superintendent Faustino here may be able to explain to the honorable body, Your Honor, with regards to that letter, Your Honor.
So ibig sabihin itong Department Order number 953 ay naamendahan?
That is the assumption and the explanation of our legal officers when I inquired about it, when I find out that there is such a department order, Your Honor.
May we hear from the Secretary? What is that letter and does that amend Department Order 953?
We only have a copy of Department Order number 953. I have no records of any subsequent written communications to that effect unless such exchange of communications happened before my time as SOJ.
Well, medyo problematic ito. Yung current secretary hindi alam kung mayroong amendment dito sa 953 at sinasabi naman ng Director General nagkaroon ng communication at ang pagkaintindi ko dito sa communication nung dating Director General at yung dating Secretary of Justice ay hindi na ina-apply yung ilang mga provision ng Department Order 953. Pero wala tayong dokumentong pinanghahawakan. Tama ba yun?
We tried to search our records but we did not find any.
So, hindi na sila membro ng, hindi na sila secretary, hindi na sila director general, pero sinusunod natin yung kanilang sinulat na hindi rin natin alam kung mayroon bang sulat o hindi. Ganun ba yun?
There's a communication that I believe Senior Superintendent Faustino can explain, Your Honor.
Well, okay, can you please put that on record?
I may recognize, Your Honor.
The chairman, with the permission of the chairman, please.
Mr. Chair, can I be recognized? Thank you, Your Honor. During we have here several communication requesting for the delegation of power to release inmates already served sentence and pursuant to the 10592. So we have made several requests dated 4 June 2018 and 27 September 2018. Then pursuant to the instruction of then former Director General of UCOR, who is now the Honorable Senator General De La Rosa, to request for the pull-out of the several documents because as early as 2016, we have sent several requests for the approval of several releases of high-risk, high-profile inmates.
Request to the Secretary of Justice?
Yes, sir. And those serving more than 40 years because we are saddled by several complaints for habeas corpus before different courts, Your Honor.
Mr. Chairman, kaya ako tinatanong ito ay dahil yung Department Order number 953, sinasabi sa number 4, in all cases, and I quote, in order to ensure that the computations made by the Bucor is accurate specifically as regards the grant of good conduct time allowance, and so forth and so on, di ba? The Director General of the Bureau shall issue a certification as to the correctness and accuracy of the computation of the credits. Ibig sabihin, dapat mayroong ganung klaseng issuance, no? At ang pagkaintindi ko rito ay ito ay dapat sinusumite sa Department of Justice dahil order ng Department of Justice Secretary ito eh. Pero ang nangyari rito, ang binibigay lamang sa inyo, base sa inyong salaysay kanina o sa inyong testimonya, Secretary Guevara, ay yung stall, yung loyalty. Pero itong good conduct, hindi binibigay sa inyo. Pero ang pinakabuod ng department order, dapat ibigay din sa inyo yung good conduct time allowance dahil kayo ang magtitiyak kung accurate ba ito o hindi. Tama po ba yun, Secretary Guevara?
Only with respect to the good conduct time allowance or other time credits of persons deprived of liberty but were sentenced to reclusion perpetua or life imprisonment according to that department order. So it's not the case that all releases will have to go through the Department of Justice. In fact, that department order grants that authority to the Bureau Court Chief. And it's only in the case of releases of persons sentenced to life imprisonment or reclusion perpetua that prior approval of the SOJ will be required.
Well, where in the Department Order 953 says that it is only for the expired, it's only for the preventive, detention? What is the term again that you use, Mr. Secretary?
Senator, it's found in paragraph 2 of that Department Order 953. The said authority of the Director General of the Bureau of Corrections to release national prisoners shall not apply to prisoners or inmates sentenced to life imprisonment or reclusion perpetua or high-risk inmates whose release due to expired sentences, that includes time deductions, shall only be implemented upon prior approval of the Secretary of Justice.
So that should be very clear.
Yes, sir.
But, and your prior approval is necessary.
According to this department order, unless it has been repealed, revoked, or amended.
Okay. Medyo maliwanag doon na may kapangyarihan base dito sa department order na ito ang department secretary na hindi na exercise dito sa kaso ni
Is validated.
Yes, thank you. Doon sa usapin naman ng good conduct time allowance, lumalabas kasi base dito sa interpretasyon ng batas ay 30 days during the 11th and successive years, which is the case of Mayor Sanchez, hindi po ba? He shall be allowed a deduction of 30 days for each month of good behavior. Tama po ba yun? Attorney Orseo? You were mentioning this. During the 11th and successive years of imprisonment, he shall be allowed a deduction of 30 days for each month. You were mentioning this. During the 11th and successive years of imprisonment, he shall be allowed a deduction of 30 days for each month of good behavior. Yun yung inimplementang batas.
Yes, Your Honor.
Yun yung sinasabing kaya siya naging eligible, quote-unquote. Tama?
Yes, Your Honor.
So, kung gano'n ang interpretasyon, kung ikaw behave ng isang buwan, 30 days, automatic, dagdag sa ano mo.
At tama po yun.
Pero, kung sa susunod na buwan, 3 beses kami sinaksak, walang good behavior.
Maski nga po isa lang gawin mo eh.
Kaya nga ginagawa kong absurd eh.
Yes.
3 beses,
Yes, Your Honor.
hindi ka kasama.
Yes, Your Honor.
Pero sa susunod na buwan, yung pangatlong buwan, behave ka na naman, wala ka na namang kaso, wala kang saksakan, 30 days na naman ang good.
Yes, Your Honor.
Well, yun ang tama ba yung batas na pag-implementa sa ganun? I don't think that is the intention of the law and the lawmakers. But precisely, ito mukha ang nangyayari rito. So pag ako nasa preso, sabihin ko, teka muna, magsasaksak ako ng 2 beses ngayong buwan na to kasi pero next month, tsaka the following month, magbe-behave ako. May minus na naman akong 60 days dahil 2 buwan akong behave. So it applies to whatever criminal act, whether it is rape, etc., which obviously is absurd, and that was not the intention and spirit of the law. Maliwan ko lang yung, hindi kasi maliwanag na nasagot. dun sa Chong case. 3 dun sa mga akusado at na-convict, namatay na. Tama. Yung iba, naka-detain pa o na-release na?
Sa Sanchez case, Your Honor po yun.
Sorry. Yes, sa Sanchez case. Yung, sabi nyo yung 3 namatay na, pero meron pa ibang akusado na-convict.
Buhay pa po, Your Honor.
Nasaan sila?
Sa loob pa po ng...
So hindi na-release?
Yes, Your.
Pero nag-apply for release?
The application of the retroactive effect of GCTA or Republic Act 1592, ang interpretation ng legal, they do not need to apply because it is commanded by the Supreme Court to record yun. So hindi siya kailangan mag-apply.
Pero they have to get your clearance, di ba?
They have to pass through the process.
Yes. And the process, where is the status? What is the status? Pareho kina Mayor Sanchez yung status ng mga kaso nila?
It's the same for every PDL, Your Honor.
Pero natigil nga dahil nga dito sa...
Yes,
okay. Doon sa assassination ng Bucor director, kasi nabanggit kanina si Mr. Traya, involved ba siya directly dito sa paghahanda ng mga dokumento ng pag-release kay Mayor Sanchez?
He's part of the team, Your Honor.
So meron siyang kinalaman o involved siya sa
Assistant, he's the next in line in the records, Your Honor.
How long has he been doing that with the permission of Senator President? How long has he been doing that?
I was informed that he's been assigned there the past 3 years, Your Honor.
3 years. So marami siyang active involvement yan.
Yes, Your Honor.
Thank you. Go ahead.
Okay, thank you. Mrs. Sarmenta at Ginoong Mr. Sarmenta, with due respect, ang tanong ko lang po dito is, you were quoted in the newspapers, parang last week ata, na parang hindi nagkaroon ng settlement o compensation o danyos. Tama po ba yun?
Yes, Your Honor.
But wasn't that the order of the court?
Yes, it's supposed to be. It was affirmed by the Supreme Court that they're supposed to pay us, but not even a single centavo or any emissary that came to us for that.
So, hindi nila sinusunod yung utos ng Korte Suprema? Ganun po ba?
Kaya nga po, paano naging good conduct po siya? Yung inuutos sa kanya ng batas, hindi po niya sinusunod. Tapos, nabasa po namin po sa kanyang general clemency, sabi po niya na pinatawad na namin siya. How can we forgive somebody who hasn't even asked for sorry or you didn't even...
So ang ililiwanag po, yes, ma'am, sorry po. Kasi medyo may clear yung panahon ko. Ililiwanag ko lang po, ma'am, na may utos ang Korte Suprema, magbayad siya ng danyos, hindi ho siya nagbayad sa inyo ng danyos. Hindi sa sumunod sa Korte Suprema, sa utos ng Korte. Tama po ba yun?
Tama po kayo.
Pero ito ngayon, hindi na nga siya sumunod sa utos ng Korte, pero ang desisyon o naging desisyon ay pwede na siyang good conduct na siya. Pwede pa ba yung Secretary Guevara, what is your sense, how can you be eligible for good conduct when you did not comply with the court ruling?
You are referring to the civil liability?
Yes, the compensation as ruled by the court.
Mr. Senator, my understanding about the civil liability arising from the offense or ex delicto is totally independent of the criminal aspect of it. So regardless of the conduct of the person deprived of liberty, whether he behaved or did not behave, the matter of payment is totally independent. And that can be enforced by other methods.
Yes, I understand that. But precisely the refusal or the non-compliance by the convicted felon, should that not be considered as precisely lacking in good conduct?
It really all depends on the particular circumstances of the case, Mr. Senator. If the person is somebody who has no ability to pay the civil liability, then
yes,
that should not be taken against him. But if we're talking about this particular person, I think that should be taken into account.
And therefore, again, it adds, well, for lack of a better term, it is adding insult to injury on the part of those who have been injured. and who have been precisely victimized, that now, because of the implementation of the law and interpretation of the provisions of the law, someone who has not complied with the ruling of the court to pay damages, civil liability aspect, can still be considered as being having exercised good conduct.
I've already given you an extra.
Yes, Mr. Chairman, we will wrap
Thank
up.
you.
So that should be also a consideration, Mr. Secretary, when you go through your review. How can someone who has not precisely complied with the ruling of the court, has shown disrespect for the court ruling, can now be can now avail of good conduct or these provisions of the law. So ang huling question lang, Mr. Chairman, yung nabanggit ito sa nabalita natin sa dyaryo na pati yung tatlong ex-convicts na nag-testify laban kay Senator De Lima, convicted na po yan. Parang nabasa ko sa dyaryo na pati sila pwede mag-avail ng good conduct time allowance. I think it was either, I don't know which, was it Secretary Guevara who was quoted?
I think the statement is based on the premise that they were not convicted of heinous crimes. Because if the violation, the drug offense committed by these 9 PDLs would fall under that category of heinous crimes, then they will have to be excluded from the benefit. But not all cases where the penalty imposed was reclusion perpetua or life imprisonment is heinous in character. That is not automatic.
No, I was raising the third question on the 13 ex-convicts who testified against Laila De Lima.
Oh, sorry. Yes, the same answer, Senator. So it all depends on whether because I'm not sure for what offenses they were imprisoned. But if they were imprisoned for heinous crimes, then following our theory that they are excluded from the coverage of this particular law on GCTA, they will not benefit.
Although in this case, I think they admitted to dealing with drugs while they were already convicts. So maybe that should be a recidivist at the very least. No? So that conduct or the misconduct or the admission of a crime while they were in detention or having been convicted already should also be considered in terms of the computation. And if I may just have one last minute.
One last question.
Yes, no more question, just to wrap up. Clearly, maliwanag na ang daming gaps dito sa implementation nung pag-release o yung pag-implementa ng batas na ito. Maliwanag dito na hindi tama ang pag-release o order of release kay Mayor Sanchez. And therefore, we hope na based dun sa magiging aksyon ng Secretary of Justice ay lahat ng gaps ay matugunan. Maraming salamat po sa pagkakataong ito, Ma'am Secretary, and to the Chairman. Thank you. Thank you.
Maraming salamat din po.
Thank you, Senator Pangilinan. I understand Senator De La Rosa waived in favor of Senator Bongo, and under the rules, when you waive, you go to the last round again. I would like to ask you to follow the rules. Otherwise, we cannot file the bill where if somebody has bad conduct, he has to start again from the very beginning. I'm not saying you have bad conduct. Go ahead.
Thank you, Mr. Chairman. First of all, the onset, nakikiramay po kami sa pamilya Sarmiento and Gomez. Being UPLB graduate, I graduated in 1990. Your children were there in 1993 when the incident had happened. As a matter of fact, many of my friends know them. Kaya it's a shock to us, to the UPLB community, when we found out that the perpetrator of these crimes, the mastermind, was about to leave jail and be free, from his incarceration. Ma'am, the whole UP-LB community supports the continued incarceration of former Mayor Sanchez until the end and expiry of his term. You have our full support on that, ma'am. Kaya gulat na gulat po kami na nangyari po yun. But thankfully, with the decision of the Secretary and Undersecretary Faldon, they decided to withhold the application or hold the application of ex-Mayor Sanchez. Unfortunately, ma'am, and for the rest of the country that's listening in, there were 1,914, as shown by this newspaper report. There was 1,914 other criminals of heinous crimes that were released already the past 4 years. Nakakatakot yung Secretary. Ano mo, kung ikaw ay biktima at mag-testify ka at nakulong successfully itong mga taong ito, and then all of a sudden they'll feign good conduct. Pepeke nila ang good conduct nila. Para makalabas sila, para bawiin o bumawi sa mga nag-akusa sa kanila. Nakakatakot po yan. It sends shivers down the spine of every law-abiding citizen, Secretary. Obviously, in this discussion today, it's clear that the law is not clear. Am I correct, Secretary? That Republic Act 10-10592 is not clear. Ang daming vague provisions. Because at one point you tell me in Section 1 or Section 2, heinous criminals are not or cannot be given GCTA or good conduct and time allowance. And yet within the document, I'm not a lawyer, Secretary, so ako ay minsan naguguluhan. Within the document, may kausap naman ako ibang abogado na pwede palang ilusot. Diba? When you ask lawyers on the implementation of the law, it's really, we get more confused actually in committee hearings, Mr. Secretary. Do you agree with me that the law is very vague?
When there are two or more interpretations to the law, then that is vague or ambiguous. Because when the law is clear, there is no room for interpretation.
That's correct, Mr. Secretary. Now, I'd like to ask you, would it be more beneficial to the country and to all law-abiding citizens if we just repeal the law altogether? Republic Act 10592 and just go back to the old system?
It's a question of policy, Mr. Senator. So if the policy remains to be more leading towards rehabilitative, reformative, rather than punitive, then I guess the best way really is to just fill in the gaps, make certain clarifications, but not to repeal it altogether. However, if the policy is now being radically changed to make it more punitive, then that is a totally different matter. And you may have to repeal not only this particular law, but even the provisions of the revised penal code itself.
So, Secretary, if that is the case, it may be too much to ask to repeal the law, especially for those who take advantage of it with minor criminal offenses. My question now, Secretary, what particular recommendations can you give? Shortly, quickly, because I only have 5 minutes of my time, Mr. Secretary. Would it be safe to say one of them is that all these petitions should go to the office of the Department of Justice, to your office for review? Because let's face it, Mr. Secretary, with all due respect to Yusek Faldon and those before you, they're not lawyers. Many of them are soldiers, ex-policemen, and many of them are law enforcers. Hindi nila minsan naintindihan itong intricacies ng batas natin, and with all due respect again to them, because as much as I would like to believe, I'm not also a lawyer, so we have to be clear upon the legal aspects of this particular law. Would it be safe to assume that, for example, there should be second tier or second layer of protection, especially for the victims of these heinous crimes, or these victims of crimes?
Thank you for asking the question, Senator. I believe that much improvement can be done, but at the level of the Department of Justice, that will not be possible my suggestion, if the committee may forgive me for suggesting or for making, is that certain amendments be made to the existing GCTA law, and if I may briefly enumerate some of them for your consideration. Number one, we would rather that the legislature state the policy more clearly. If you will notice, this law doesn't have any whereas clauses. The policy or intent of the law is stated normally in the whereas clauses. But this particular law does not contain any whereas clauses that would indicate the purpose or the policy of the law. Number two, what I'm saying by policy, Mr. Senator, is to determine whether the main thrust of this law should still be on the reformative or rehabilitative side, or do we go for the punitive or the retributive side, or a combination of both? If it's both, then which will have preponderance? The rehabilitative over the punitive, or vice versa? That has to be clearly spelled out, Mr. Senator. Number two, the provisions of this law should be more should be crafted better, in a better way. We came to the conclusion that the intent of the law was to exclude those convicted of heinous crimes, as well as habitual delinquents, escapists, recidivists. But that came only after a tedious and laborious harmonization of the various provisions of this law. Had it been clearly stated in one single provision, stand-alone provision, that the benefits of this law shall not apply to these classes of people, then we probably would not have a confusion such as what we have now.
Thank you. Thank you, Secretary.
Number three, if I may.
Go ahead,
Just complete it, Mr. Santo, because I may not have the opportunity again. I would rather that the heinous crimes covered be expressly enumerated in the law. Because we are going by a definition of heinous crimes, which is found in another law. That enumeration of heinous crimes is found in the death penalty law of 1993.
That's correct.
All right, there are two classes of crimes enumerated there. One is where the penalty of death is mandatory. And for that reason, those offenses where the death penalty is mandatory are the ones classified as heinous. The second class of offenses enumerated in the death penalty law pertains to those where the court will have discretion on whether to impose reclusion perpetua or death. So depending on the actual circumstances of each case, the court will determine if death should be imposed or reclusion perpetua only. So there is an avenue there that the crime committed may not be a heinous crime. Yes. So in other words, of course we all know that in 2006, this law, the death penalty law, was repealed. All right, and in the sense that the imposition of the death penalty was now prohibited. But we are of the opinion that the only provision affected by the repealing law is only insofar as the imposition of the death penalty is concerned. But the classification of offenses, whether it's heinous or not, remains in that law. And we are using that remnant of that law as basis to determine whether a crime is a heinous crime or not. Now, in the proposed bills affecting the GCTA law, we would rather that the enumeration of heinous crimes be included there, so that there will be no room at all for any doubt on what is covered or not.
Mr. Secretary, I'm just worried that the chairman might cut me off. I'm only given 5 minutes.
Yeah,
If
but
it's all right with
I
the
think
chairman
it's
that, to allow him to continue with
I
the
just have two
enumeration.
more suggestions.
Okay. Yes.
My
Go
answer
ahead,
is not
Secretary.
counted.
Go ahead, Secretary.
Number 4, we would like to have transparency provisions in any amendment to this law. Transparency in the sense of maybe publication of the names of PDLs who may be released by virtue of the expiration of their sentence, whether full sentence or abbreviated sentence by virtue of good conduct. Number 5, and the last, we would rather that there be a provision on oversight by Congress. This is obviously missing in a very important law like this. As we are experiencing now, we are conducting this this public hearing because the Congress wants to know how this law is being implemented. There's nothing in the present law that creates for oversight functions. We would rather that Congress insert that provision of oversight.
But that is inherent. We're doing oversight right now.
Thank you, sir, but it will be a
But
lot
the
better.
suggestion is well taken to be more explicit. Is that
Yes.
it? Yes, thank you.
Thank you
Thank
very
you,
much,
Chairman.
Mr. Sen.
Thank you, Secretary. Thank you, Chairman. Just actually one last very important point, one last question. We have a bill, Mr. Secretary, together with our colleagues here from the different agencies, creating, it's by the Senate President himself, Senate President Soto, which we fully support. No, we've had a caucus about it, and we said that we'll be voting on it favorably. And this is the bill creating a high-security jail complex. A brand new, you can call it Alcatraz. Ito po yung high-risk facility na sana hindi na po ito country club setup. Hindi na po siya parang country club. Wala na po mga kung ano-anong luxurious items. This will be similarly set up to the federal prisons of the United States and in isolation from cities and high population areas. And the reason why this is actually initially for drug traffickers, high-level drug traffickers, but we all agreed to already expand it to criminals accused of heinous crimes or convicts of heinous crimes. The reason, Mr. Secretary, is because number one, many times throughout several years, media has assisted us in uncovering anomalies in the prison system, wherein there are offenses of prison rules. For example, I recall one time coming home from, I believe it was either Congress or the Senate when I was still a congressman, Anthony Taberna, in his DZMM show, exposed a convict accused of murder that was actually loitering around or moving around the mall, with certain personnel. And then, na pumutok po yan and lumabas na may ganong klaseng arrangement na binibigay pala at that time. Of course, I hope it was corrected already by this administration. But, Mr. Secretary, would you agree with us that we need this kind of facility? Because it's obvious it's not stopping. No matter who the president may be, parang ang dami pa rin tayo nakikitang nakakalusot sa prison rules at nabibigyan ng special consideration. Would you support such a measure, Secretary?
Definitely support that kind of measure.
Maybe last question, Mr. Chairman, to the VACC. I know marami na silang pinaglaban. Nandyan po yung aking mista na si Dante Jimenez, together with the head now of the VACC. May we ask a comment from you if you will support particular high security prison system or complex where we can keep all heinous criminals in one place without cell sites, without the comforts of being close to a mall, without comforts of being able to escape overnight and come back again in the daytime to take his role when there's a roll call. How would you?
Okay, Your Honor, we fully support that suggestion. As a matter of fact, for the past 3-4 years, we are suggesting that structure like similar to Alcatraz in the U.S. Alam naman po natin, ang Pilipinas is consisting of 7,000 islands. So since we can we can tap those islands to keep them isolated, especially high-value targets or high-profile cases.
Yes.
And also to distribute convicts. So not to breed familiarity with each other.
Actually, Your Honors, Mr. Chairman, the idea was to put them in an island. Ika nga. So anyone who would come approach the island would be either, it has to be either friendly or enemies, you know, or trying to, or people that are trying to escape, living in and out of the island. And at the same time, this would be a cornerstone of the President's anti-corruption, anti-criminality program. If he can build a facility such as this, magkano lang naman po yan? You know, Mr. Secretary, prime real estate na po yung Muntinlupa. We had a discussion with that with the Secretary Medialdia in the LEDAC the other day, and we said, you know, you privatize or you bid out Muntinlupa, you can raise up to about 300 billion pesos. I think it's about 300 plus hectares or 380 hectares at 50,000 per hectare lang. That's already almost 200 billion pesos. Kung 100,000 per square meter yan at maraming bibili niyan dahil ang BGC na yon ay 1 million per square meter, ay siguradong malaking pera para sa gobyerno yan. They can get a portion of that to build this high-level, high-security facility to keep these people in. And hindi na po siya country club para matakot naman po ang mga kriminal natin dito sa bansa na pag nahuli sila, hindi parang baliwala lang na parang pa rin silang nasa loob ng isang hotel at they can still conduct criminal activities. So I thank you. I believe Senate Chairman Dante Jimenez would just like to say something.
Yes, your Chairman. First of all, yes, I support such an idea. But before everything else, let me say that we are here because representing also the other victims of these crimes. Yes, we have tackled in the hearing the cases of Ms. D. Sarmenta and Gomez cases. But you see, in the VACC, which I'm the founding chairman, thousands are now listening to this hearing because they would like to find out whether their convicts are part of those 11,000 that has been mentioned in many occasions. So I'm happy that the Secretary of Justice is really wants an amendment, and at the same time, if not amendment, if you can already be transparent, give all the list of the convicts that are due for GCTA. Lahat nagulat talaga nung pumutok itong kay Sanchez. Pero how about those na mga hindi kalalang mga kaso? Ito po ang aming nire-represent po dito sa ating hearing, Mr. Chairman. Lastly, on the area of corruption, because I'm also the chairman of the Presidential Anti-Corruption Commission, we are going to also start our investigation in accordance with Executive Order 73, Section 5, particularly on Republic Act 1319, and after due investigation and 5E, recommend to the President filing appropriate criminal complaints before the Office of the Ombudsman, Department of Justice, or otherwise refer to such cases for appropriate action to these offices. So that is my presence here. Aside from the representing the thousands of victims now listening to this hearing, waiting, may pag-asa pa na mailabas ang mga pangalan, malaman nila, because hindi nila alam kung anong proseso, anong sistema. Number 2, kami po sa PACC conduct our own investigation, Mr. Chairman. Maraming salamat po.
Thank you then, Mr. Chairman. Thank you for the time.
Thank you, Senator Sibili. Thank you, Mr. Jimenez. We now call on Senator Bato de la Rosa. Can you stand up here, please, in the front? While he's preparing, I just want to ask Maynard, Secretary Maynard about Section 1 of RA 10592,
when we were perusing the law, I know that there's a distinction made pertaining to preventive imprisonment, no? And very quiet on the convicts, no? But there's a provision there, and I know, and I will premise this, that they were talking about preventive imprisonment. But at the last paragraph, at the last line, it says, Section 1 of RA 10592, amending Article 29 of the Revised Penal Code, provides for credit of preventive imprisonment. That's what I was saying. Article 29 expressly states that recidivists, habitual delinquents, escapees, and persons charged with heinous crimes are, and that's why I maintain that they could be covered, excluded from the coverage of this act. So in other words, kasama sila. I mean, an argument can be made for that. Huh? Diba? Hindi naman sinabing section this act.
That is one of our arguments for adopting, apart from harmonizing
it supports
Section 1 and Section 3, we also
your position
rely
and our position
exactly
that heinous crimes are, for heinous criminals, they will not benefit from this law, correct?
That is correct, because otherwise, if the intention was only to exclude them from the benefit of Section 1 pertaining to preventive imprisonment time credit, then that would have been clearly stated. But the provision, the sentence says, from the benefits of this act, the entire act.
And with the permission of Secretary Senator De La Rosa, just one last question. And the matter of retributive justice and reformative justice, most of our laws, according to our constituents, says, they say, and we agree, are purely retributive, may mga penalties na malalaki, di ba? Pero kanina, habang natatanong ako kay Mrs. Sarmenta at sa Ivan, tinanong ko sila,
Parami ang guminhawa sa Santon Plus Herbal Capsule.
Ako si Jay Enriquez, isang estudyante. Problema ko ang mataas na sugar noon. Nag-change lifestyle ako at uminom ng Santon Plus Herbal Capsule. Wala na problema ko sa cholesterol.
Mabibili sa mga suking butika.
Mahalagang paalala, ang Santon Plus Herbal Capsule ay hindi gamot at hindi dapat gamitin panggamot sa anumang uri ng sakit.
Mula sa #1 na Smart Dishwashing Paste,
ang galing mo.
With over 80% more cleaning power kaysa leading liquid brand sa presyong mas abot kaya.
Smart, ang galing mo.
May double tanggaling formula. Tanggal galing ang sebo at bakterya.
Smart, ang galing mo. Kaya ikaw ang #1.
Smart Dishwashing. Tanggaling-galing.
ACS.
Smart Dishwashing. Manufactured by ACS Manufacturing Corporation. ISO certified world-class quality.
Marami na ang natulungan na Nature Soya Coffee.
Ako si Femia Limi, isang housewife. Madalas akong kabagan pag umiinom ng kape, kaya naghahanap ako ng walang caffeine, solid nature soya coffee na ako ngayon.
Kayo rin, gumamit na ng Nature Soya Coffee. Mabibili sa mga suking butika.
Mahalagang paalala, ang Nature Soya Coffee ay hindi gamot at hindi dapat gamitin panggamot sa anumang uri ng sakit.
This news is brought to you by EO Executive Optical. If you love your eyes, come visit EO Executive Optical today for expert eye care. With over 100 branches nationwide to serve you, EO has been voted by consumers as a Reader's Digest Trusted Brand 2016-2017 Platinum Awardee.
Sarah Geronimo po. Daddy ko, labo ng mata. Sinama ko siya sa EO Executive Optical for expert eye care. Nung binigay salamin ni Daddy, sabi ng optometrist, I care for you, sir. Si Daddy, kinilig. I care for you, Daddy.
EO Executive Optical. Love your eyes. If you love your eyes, come visit EO Executive Optical today for expert eye care. With over 100 branches nationwide to serve you, EO has been voted by consumers as a Reader's Digest Trusted Brand 2016 Platinum Awardee.
Narito ang isang patunay ng sarap at bisa ng Nature Soya Coffee.
Ako si Jenny Lynn Salvador, taga San Miguel. Sumasakit ang tiyan ko pagkatapos kumain. Sinubukan ko ang Nature Soya Coffee. Nagtulungan nito ang pagnormal ng feeling ko.
Kapengwa ng caffeine, Nature Soya Coffee. Mabibili sa mga suking butika.
Mahalagang paalala, ang Nature Soya Coffee ay hindi gamot at hindi dapat gamitin panggamot sa anumang uri ng sakit.
DZXL Special Coverage.
Pinirmahan ko, isa lang dyan, yung convicted ng RA 6425, Dangerous Drugs Act. Isa lang po ang napirmahan ko. I just want to set the record straight kasi sabihin nila totoo yung report ng newspaper, 384 sa akin. Hindi po, 120 lang. Possibly pa, bababa pa yan. Dahil pacheck ko yung records doon. At isa lang po, lahat yan ay rape, murder, robbery. Isa lang po ang drug case. Marami ang murder. Tumawa si Sir Senator Ricto. Mr. Chairman, I would like to ask this question regarding GCTA for sale. As alleged by some PDLs via Senator Risa Hontiveros. Tanungin ko lang muna si Attorney Santos. Kasi kayo, si Mel at saka si Director Paildon, kasi kayo yung pinapa-lifestyle check ni Senator Amy Marcos. Totoo ba na mayroong GCTA for sale dyan sa Bucor? Can you answer me?
That is addressed to Secretary Paildon, Undersecretary Paildon, right? Undersecretary Paildon, not to Mr. Santos.
Sa kanilang dalawa, sir. Si
No.
Postino and Paildon.
No. We called
Paildon.
Mr. Paildon.
Yes, sir. Meron bang GCTA for sale sa Bucor?
Kasi automatic yung pag-grant ng GCTA, hindi naman siya kailangan hingiin. Because it's based on the number of years, ilang buwan ka naging behave. So, I still have to investigate this, but kahit hindi nila hingiin, i-grant sa kanila kung nag-behave sila. So, hindi ko makita kung kailangan nilang magbayad para mag-grant sa kanila yung GCTA.
Thank you.
But we will investigate, Your Honor.
Attorney Mel Postino, meron bang GCTA for sale dyan?
I subscribe with the... sumasangayon po ako sa sagot ni Director General. Wala naman pong dahilan para bumili ng GCTA.
Okay. Attorney Santos, tanungin kita, anong papel ng mga paralegal dyan sa Bucor? May tinatawag kayo dyan ng mga paralegal. Ano yan sila?
Sir, yung paralegal po, pagka mayroong mga legal issues, yung mga...
Not recognized too.
Sir,
It should be really the Director General who should answer. Go ahead. Okay. You can advise him what to answer. Go ahead.
The paralegals, as far as I know, these are PDLs. There are a lot of lawyers inside who are serving sentences inside. So these are specifically regarding GCTA. If you go inside our facilities and ask any PDL, he knows how to compute the exact date of his release based on GCTA. So these are the roles of the paralegals inside our facilities. They teach the inmates on the computation of their time allowances based on good behavior, based on studies, teaching and mentoring, and some instances stand. So every PDL, if they spend more than 5 years inside our facilities, know exactly how to compute, even
So these are
manually.
former members of the bar.
Yes, sir. And
inside jail, and you're using them.
the,
That means
the,
they'll
the
get good
PDLs,
conduct. They will get good conduct. Pa.
yes, sir. The PDLs who are
Allowance.
former members of the bar are helping understand the laws.
Thank
that
you, thank you,
covers.
thank you, General Paildon. Mr. Chairman, I am trying to bring this out because I just would like to share with you my personal experience as Director General of Bucor. I'm not lawyering for Bucor, but in fairness, I would like to set the record straight. Yung aking experience dyan, whenever bababa ako sa opisina ko, pagbaba ko sa opisina, may nag-aabang sa akin dyan sa baba ng opisina. Asawa, anak, ng mga PDLs na sa loob. At ang palaging complain nila, Sir, maawa ka naman sa amin. Wala kaming pangbayad sa GCTA. Kaya hindi kami bibigyan ng GCTA yung aking asawa. Dapat matagal na yang nakalabas. According to them, sir, according to them. So, sabi ko, sinong nag-compute dyan sa inyong computation? Sabi na, sir, yung paralegal na si ganito, sir, nag-compute. Okay, you come with me, samahan ko kayo sa loob ng inmate documentation processing section pa yun, panahon natin. Kusama kayo doon. Pagdating ko doon sa IDPS, pinatayo ko lahat ng empleyado. Ilang beses ito eh. I really carry a big stick, Mr. Chairman. Nung malaking...
that is not a stick, that is a sword.
No, stick yung hindi ratan. Kamagong, Mr. Chairman. I used to tell them, I don't care kung matanda na kayo dito sa Bucor. Pero kung na-prove ko sa inyo na kayo nagbibinta ng GCTA dito, itong kamagong na ito, lulumpuhin ko kayo. Siguraduhin ko sa inyo yan, lulumpuhin ko kayo pag kayo nagbibinta. Sino nagbibinta ng GCTA dito? Sir, wala po. O bakit ito nagkiklaim itong asawa? Pakita ko yung record nila. Please. Tingnan nyo. Kasi kawawa ito, babalik-balik ito dito. Walang pamasahe, walang pabili ng bigas, tapos pabalikin nyo para lang sa GCTA na yan. Tingnan nyo. Compute. Kinompute nila yung GCTA. Kalabasan ngayon, yung totoong computation galing sa documents. Sir, hindi pa qualified. Itong computation na tama. So lumalabas talaga, Mr. Chairman, na lahat ng, and I'm not referring to the ones complaining to Senator Risa Hontiveros, karamihan dyan, yung mga hopeless na mga PDLs, pupunta yan doon sa mga paralegal. Mga paralegal naman, very enterprising. Sino sa inyo dyan gusto nang lumabas? Sabi ng mga paralegal, ako, tulungan mo ako. Ito yung aking records. Sige, halika dito, kumite ko. Pero, may consideration. Bigay ka, kasi kailangan ko ng typewriter na gaganito, may papel na kailangan. So, pagganahan niya yung pinapaganahan niya yung priso, yung PDL. Uy, matagal ka na pala dapat nakalabas. Itong competition ko. Pero, kung i-compare mo yung competition na yan, doon sa totoong competition ng document section, hindi talaga qualified yung mga tao na yan. So, itong mga tao na ito, tinatanong ko, pagbaba ko, sinong, sabi nyo na nagbibinta ng GCTA, sinong nakabili? Bigyan nyo ko ng pangalan kung sino. At talagang uupakan ko yan. Sir, wala kami may bigay, pero balita namin, sir, meron daw gano'n. O balita lang yan, puro hearsay. In fairness naman ito sa mga tao na ito, itong mga taga-Bucor. When I was at the outside, I really hate Bucor. Bakit palaging Bucor pagdating sa drugs transaction, Bucor? Pero nung akong pumasok sa loob, I learned to appreciate their patience, their heroism. Marami sa kanila, Mr. Chairman, pinabaril na mga drug lord dahil ayaw mag-give in sa kanilang demand. Marami dyan sa kanila, binaril dahil ayaw mag-give in sa mga drug lord. So, yung sabi ko, hindi ito dapat mangyayari kung meron tayong death penalty. Yung mga drug lord na yan, dapat matagal na binita yan, hindi makapagbaril ng mga taga-Bucor. But anyway, wala man talaga tayong death penalty sa ngayon. Ang akin lang talaga is to set the record straight as far as I'm concerned. During my term, I've been investigating lahat about GTCA for sale, but wala talaga akong nakita na merong nagbibinta. Yun ginagawang scapegoat ng mga tao na frustrated na doon sa loob at inaakusa itong mga taga-document section na nagbibinta daw ng GCTA. Dahil nga hindi sila nagkukwalify. Dahil nga itong mga enterprising na mga paralegal ang gumagawa ng sariling computation which is not in accordance with the supposed computation provided by law. Kaya napoprostrate sila, ina-accuse lang ngayon na nagbibinta ng GCTA.
Thank you.
So yun lang sa akin.
Senator Badok, I just got a text from, or a letter from, a note from the Senate President that we have to adjourn because it's almost 3 o'clock. And you still have 5 minutes from Senator Erecto.
Salamat, Mr. Chairman.
Yeah.
Thank you.
I hope you don't mind, but
okay lang. Mayroon pa bang bukas?
May pabukas pa tayo. May question ba yun?
Sir.
Hinahanap ni Senator Dillon yung question mo.
Iyon pang
No, sir. They are inmates din, mga PDLs din, na kunyari, abogado, kunyari, teacher, kunyari, basta ganun. Paralegal ang tawag sa sarili nila. May sarili silang competition.
Meron ba mga tiga-UP doon?
Isa lang, Mr. Chairman. Bago ako mag-alis, isa lang, kunti. Ito para sa aking former boss, si Secretary Guevara, sir. As a non-lawyer, I am confused. Please enlighten me. Ganito yung nangyari. Yung mga Supreme Court ruling na nagsasabi doon sa mga petitioner na okay, you are covered by this law retroactively. Meron yan sila siyam na mga petitioners. Sinabihan sila na Supreme Court, kayo, covered. Pwede kayo mag-avail dito, retroactively. Posible ba na hindi alam ng Supreme Court na itong siyam na na petitioners are convicted of heinous crimes? Kasi pag sinabi ng Supreme Court na pwede kayo, covered kayo, pero alam ng Supreme Court na heinous crimes yung kanilang conviction, so it clearly support the stand of Bucor.
Is there a question around the corner?
Sir? That's,
Oh, yeah.
yes, sir.
What is the answer?
It depends on the pleadings filed by these 9 petitioners. I have not seen those petitions, so I wouldn't be in a position to know whether they admitted to the Supreme Court that as petitioners, they were sentenced to, convicted of heinous crimes. That all depends on whether that information was alleged in the petition filed by these 9 inmates that you were mentioning. But as far as I know, Mr. Senator, the Supreme Court really limited itself only to the resolution of the issue on retroactivity and nothing more.
Hindi lang nasama.
Yes, sir, but yung siyam talaga, specifically, nakasama kayo. So pag sinabi ng Supreme Court na kasama kayo dito, covered by this act, dapat alam ng Supreme Court na heinous crime yung kanilang conviction. But anyway, thank you, sir. Maraming salamat po. Mr. Chairman, thank you.
Thank you, Senator. I'm sorry that I have to rush you because of, because last time we extended by an hour. Finally, we have Senator Recto.
Thank you, Mr. Chairman. Most of the issues have been ventilated earlier as I was watching the proceedings from my office. I only have one last issue to ask of, one last issue, Mr. Chairman. And let me ask the Secretary. Secretary, what is the procedure and who signs the final order for pardon?
On the matter of executive clemency,
yes,
Senator, the matter is processed by the Board of Pardons and Parole.
Mm-hmm.
So they review the carpeta or the case files of the person concerned and determine if there will be sufficient justification to recommend the grant of executive clemency to that person, whether it be absolute pardon, conditional pardon, or commutation of sentence. Then that recommendation is submitted to the Secretary of Justice, if I'm not mistaken. So it goes to us, and we transmit that to the office of the President. Now, if the recommendation...
So there is a vetting process.
Sorry, sir?
There is a vetting process.
There's a vetting process, obviously, Mr. Senator. So if the recommendation of the Board of Pardons and Parole is negative, not for the grant of executive clemency, then that's the end of it. Nothing for us to transmit to the office of the President anymore. But that fact alone does not preclude a direct recourse to the office of the President, because the power of the President to grant executive clemency is plenary and absolute. It doesn't have to depend on the recommendation of the Board of Pardons and Parole.
And that is constitutional.
And that is according to the Constitution.
So the Constitution authorizes the president.
Yes, absolute and plenary power.
Is there any other mode to reduce one sentence? So you have pardon, what else do you have?
This, exactly,
Parole.
the GCTA is one
the
avenue
other- yes.
to shorten the sentence, and of course, well, parole is totally different matter.
The
It's
parole,
a
how does
conditional
that work?
release.
How does that work?
Parole is a conditional release granted by the Board of Pardons and Parole, subject to certain conditions like visiting the parole officer occasionally or from
Yes,
time to time.
yes, yeah.
And if there is any violation on the part of the parolee, for example, he commits a crime, then that parole will automatically be
So
revoked.
it's
and
still, it is the same board.
Same board, the Board of Pardons and Parole.
And who signs it? The Secretary of Justice?
No, the Board of, does it go? The Board of Pardons and Parole has control over this matter, but the Department of Justice, Senator, is represented in the board by one of our undersecretaries,
Yes.
who acts as chairman ex
Who
officio.
issues the parole? Who authorizes the parole?
The Board of Pardons and Parole.
Who is the final signatory?
Well, all of them, all of the members of the board.
So
of
it is a
Pardons and Parole.
resolution passed.
A resolution passed by the board.
And that is found in law, creating that board.
Yes, sir. I think in the indeterminate sentence law,
Okay?
or
Okay.
all
And
right,
now,
its own law on the
and-
Board of Pardons and Parole.
and today we're discussing Republic Act 10592.
That is correct. That is a totally different
Correct,
matter.
correct. And in 10592, it is a very short law. It is only 3 pages long.
That's what I noted. There's nowhere as close as could be found in that
Yes,
law.
there is no declaration of policy. Now, having said that, Mr. President, what section in this law authorizes the Director General to release any prisoner under this law?
Nothing.
There is nothing.
There's nothing.
So why is it that the Director General has the authority today to release prisoners under this law? If there is nothing in the law that authorizes him to release.
Well, it must be based on some other law, not on the GCTA. Bureau of Corrections Act. It's the law that strengthens the board or the Bureau of Corrections that authorizes.
But
or
it is
gives that
not in
authority.
this law.
No, not in that law.
Okay?
Some
Now,
other law.
Some other law.
The Bucor law.
Okay. So you mean to tell me the Bucor law authorizes the Director General to release prisoners? To approve the release. Okay? Now, remember, we're talking about the law 10592. All these issues was brought about because of this law.
Yes.
And when I review the law, there is nothing here that authorizes the Director General ordering the release of any prisoner based on the time allowance granted here. Section 5, Article 99, the title is who grants time allowance, not authority. It doesn't grant authority to the Director General to release. The title alone says who grants time allowance. Tagabigay lang ng time allowance at tagabilang lang, but not to release.
That is correct, Senator.
That is correct. So, how is it that 2,000 inmates have been released by 4 previous Director Generals when there is nothing in the law that authorizes it? Tagabilang lang ng time allowance eh. And that's why there are only 10 sections. Okay? Many of the sections deal with the counting of the allowance. Okay? The Director General of the Bureau of Customs, the Chief of Bureau Jail Management and Technology, the Warden, tagabilang ng allowance. But not necessarily to release the prisoner. And then you have Section 7, implementing rules and regulations. Now, I suppose that in the implementing rules, dapat yung Board of Pardons din. there is a vetting process. Binilang nila, they can recommend to the Board of Pardons whether or not this prisoner is eligible. That is my interpretation of the law.
In the implementing rules and regulations, Mr. Senator,
Yes.
The creation of an MSEC or Management Screening and Evaluation Committee is created, and
Yes.
that is that screening committee which evaluates.
Yes. In fact, I went over the implementing rules. Nothing there talks about also the chief of the Bureau of Corrections that is authorized to release prisoners.
Because it is found in another law.
Yes, I understand. But with regard to this law, I don't see any authority given to Emir in this law. And as you said earlier, there is none. Now, finally, what happens now to the 2,000 that have been released? Ano yan? Pauhuli ba natin yan? Pababalikin ba natin yan? Now, under the same article, it says, whenever lawfully justified. In the same section. Meaning to say, yung pagbilang ng time allowance, dapat lawfully justified. Kung hindi siya lawfully justified, baka pwedeng ihuli ulit. I suppose that's where the President is coming from. If the President did order na hulihin ninyo ulit lahat yan. Siguro nakita ng Pangulo o yung sino man ang nag-advise sa kanya that there is this section whenever lawfully justified. Could you care to comment, Secretary?
I noted that particular phrase as well, Mr.
Yes.
Senator.
Yes.
Whenever lawfully justified,
Justified.
then GCTAs shall be or may be granted by the Bucor Chief or the BJMP Chief, and so forth and so on. So conversely, if the grant is not justified, or rather the basis for the grant is not justified, then it follows that the grant is null and void.
Okay.
And for that reason, appropriate remedial action may have to be taken. As to what exactly that is that a recommitment? Is that by virtue of a warrant? That's something for us,
Yes,
to further
consider.
flesh
Yes.
out.
Yeah, so, in summary, one, I think we agree here that nothing in the law, in this law, authorizes the Director General to release prisoners. Not he, not the Chief of Bureau of Jail Management and Penology, and not a warden. There must be a procedure. And I suppose you have to take this law with all the other laws together in releasing prisoners. No? Okay? And second, meron palang pwedeng gawin. Doon sa 2,000 pinakawalan, pwedeng gamitin din yung batas na to para hulihin dahil hindi lawfully justified. So thank you very much, Mr. Chairman. Thank you, Secretary.
Thank you, Senator Recto. I just would like to say that tomorrow we're resuming the hearing at 10 o'clock in the morning, same place, same guest, with an addition of some. We'd like to finish by tomorrow, and we will include the amendments to the law, so the points of the Secretary of Justice are well taken. We'll take note, and we'll draft in the law as we speak, the bill as we speak. I would like to tell everybody, if I may have your attention, that we're very relieved that Mrs. Gomez has come back from the hospital. This is just goes to show everybody na ang gravity nito pinag-uusapan natin. Talagang masakit. Tinamaan na tuloy ng high blood pressure attack si Mrs. Gomez, and I really apologize to her for the inconvenience, but we really had to ask those questions because talagang napakahalaga na makuha naman yung side ng mga tao na offended party na kumisan nakakalimutan na isa sa tabi. And it's important that we all remember that we are all human and that kailangan rin talaga makasama yung mga tao na talaga nasaktan. No? At hanggang ngayon nasasaktan. So, I would like to thank everyone for coming here today. Tomorrow, yes, Senator Rivera.
Mr. Sarmenta
and be already excused from tomorrow's hearing if they want to excuse. Just to repeat for the record, may we move with that Mr. and Mrs. Amenda and Mrs. Gomez be excused from attending tomorrow this hearing. It's not easy for them to attend this hearing. They can come if they wish to, but they are not compelled to appear here. That's my motion, Mr. Chair.
Well, ma'am, sir, it is up to you if you want to come. You can come. We would like you to come. If you feel that you want to see and oversee what is happening here, you are most welcome because indeed you are the focal point of this investigation. So, ma'am, if you're going, you'll be most welcome. But if you cannot make it, if you feel it's too taxing, please be assured that we will try to make sure that justice is done here. Ma'am.
Yes, Your Honor. Thank you very much.
Thank you, ma'am. So, we have run out of time, 3 minutes to game time here, meaning the session. So, with your permission, I will suspend the hearing until tomorrow. We will see you all tomorrow. Thank you very much.
Kasamang Grace.
DZXL Special Coverage.
Mula po sa Senado, kasamang Grace.
Tinapos na ni Senator Richard Gordon yung pagdinig ngayon, pero sabi niya, masusundan pa uli ito bukas. Ang dinidinig po ngayon ay itong kontrobersyal na pagpapalaya sa mga bilanggo sa karumal na hinatulang guilty sa mga karumal-dumal na krimen gamit nga itong GCTA law o Good Conduct Time Allowance Law. Kaya sila ay napalaya. Well, ngayon na